This video demonstrates how to create a comprehensive shareholders agreement and a Memorandum of Incorporation in accordance with the Companies Act 2008, together with the special resolution that is required in order to register the Memorandum of Incorporation. Typically, drafting these documents would take a corporate lawyer well in excess of 5 hours. Let's see how long it takes on the company law system. Start by selecting the correct product, then the number of shareholders. Insert the names of the shareholders and their ID numbers. Then their domicile address. Apologies for that. Domicile address, number of shares held. Right, that completes the shareholder information. We then insert the company's name. We can validate this information through the Companies and Intellectual Property Commission's offices. We select the correct company. What happens is that the company information that's available on the CIPSI system pre-populates in the required fields. Then we select whether or not the company elects to undertake a statutory audit. In the next section, we deal with the board of directors, starting with the notice period for board meetings. And there are then two further questions relating to how the board is appointed and how the board votes. Starting with the voting of the board, there are two options. Either the board members can have one vote each, or they can vote in accordance with the shareholding of the shareholder that appointed them. We select the first option. Then we deal with the appointment of directors. There are three options here. First, the draftsman can specify that for each specific percentage of the issued share capital held by a shareholder, he or she will be entitled to appoint a single director. Second option is that for each specified percentage of the issued share capital, such shareholder shall be entitled to appoint one director. In other words, under this option, if a shareholder holds 60% of the shares and the percentage is set at 20%, he would be entitled to appoint 3 directors. In the next section, we record the share capital and the number of shares. The ordinary and special resolution thresholds, and whether or not the company shares have a par value or not. The next section deals with preemptive rights. In the event of a deemed sale event taking place, the first question requires the draftsman to insert the time period within which the purchase price must be paid. Then we have the usual tag-along and come-along provisions. Then we finish off the section with two further questions. The first is, who will determine the purchase price in the event of a deemed sale event? And lastly, in the event of the death or permanent incapacity of a shareholder, what will transpire with the shares that are held by that shareholder? And here we have three options. First, the shareholder automatically offers to sell his shares to the remaining shareholders who are obliged to purchase the shares. In other words, this would give rise to an automatic sale. The second option is that the shareholder or his or her estate will be deemed to have offered the shares for sale, but the remaining shareholders are not obligated to buy those shares. Finally, the draftsman can elect to provide that the shareholder's estate continues to hold the shares. In the final section, we deal with the effective date of the shareholders' agreement. where disputes will be arbitrated, the level of experience that the arbitrator must have, and who will be liable for the costs of preparing the shareholders agreement. That completes the process of drafting the 3 documents, and these documents are then made available to the user both in PDF and in Word format. The drafting of the documents has taken us a little over 5 minutes, a fraction of the time that it would typically take a corporate lawyer to draft these documents. Let's take a look at the PDF version of the document that's been created. It comprises the special resolution, the Memorandum of Incorporation, and the shareholders agreement. The PDF comprises 43 pages, and the document is accurate in terms of the most recent developments in company law. It includes the fields that the user has selected and the options that the user has selected in the preparation of the document. The document is available to the user in PDF and Word format. If customized drafting is required in relation to the document, the attorney can simply access the Word version thereof. The company law drafting facilities add value to an attorney's practice, saving the attorney time in the drafting process and ensuring that a professional product is delivered to the client. Company law includes various different categories of documents, including company law documents, employment law documents, credit-related documentation, leases, etc. For more information, visit companylaw.co.za or call us on 011 783 8017.